Something massive is happening in Washington. The Supreme Court is preparing to rule on a case that could erase decades of political advantage for Democrats, and it's closer than anyone realizes. At the center of it is one question: should voting districts be drawn by race or by population? That single decision will decide who controls Congress for the next generation. If Section 2 of the Voting Rights Act falls, Democrats could lose between 20 and 30 seats overnight, a shift so big it would change every election from now on. And the timing couldn't be worse for them. Let's break down what's coming, why it matters for you, and how this one ruling could end the era of engineered political dominance in America. Think about the last time you looked at a congressional district map. There's a reason they look that way, and it's not geography. It's mathematics mixed with ideology wrapped in the language of civil rights. For decades, these maps have been drawn with one invisible ingredient baked into every line: race. Now, the Supreme Court is asking whether that's still constitutional, whether America has changed enough that we can finally stop sorting voters by the color of their skin. The case is called Louisiana versus Clay, and on the surface, it seems technical, just another redistricting dispute. But beneath that legal language sits a question that will reshape power in Washington for a generation. The justices aren't just deciding one map in one state. They're deciding whether decades of so-called majority-minority districts, those intentionally carved out around racial populations, still have a place in modern America. That single question could unravel nearly half a century of political engineering. And here's what makes it explosive. Democrats know that if the court says no, their structural advantage in Congress evaporates, not gradually, overnight. To understand why this moment matters so much, we have to look back to where it all began, to the spring of 1965, when America was still reeling from the violence in Selma, Alabama. You probably remember the images, or you were there yourself. Peaceful marchers beaten on a bridge, citizens demanding the simple right to vote without intimidation, without impossible tests, without fear. The nation watched, horrified, and Congress responded with the Voting Rights Act. President Johnson signed it into law, and it was supposed to be the promise that finally made equality real. Every vote would count, every citizen would have a voice. And for a while, that's exactly what it did. The act tore down barriers that had kept Black Americans from polling places for generations. It banned literacy tests. It sent federal observers to oversee elections in places with histories of discrimination. It was, by any measure, a triumph of moral courage translated into law. But something happened over the decades that followed. That noble goal, equal access to the ballot, slowly morphed into something different, something more calculated. Legislators discovered they could use the law not just to protect equality, but to design outcomes. They learned how to carve districts in ways that guaranteed certain results. Social justice got recoded into geography. What started as protection became engineering, and the people doing the engineering were very, very good at their jobs. By the time we reached the 1982, a new strategy had taken hold. Democrats, working with civil rights groups, figured out how to turn the Voting Rights Act into a permanent advantage. Here's how it worked. If you packed minority voters, who overwhelmingly voted Democrat, into specific, heavily concentrated districts, you could mathematically guarantee dozens of blue seats in Congress. You'd create what came to be called majority-minority districts.
On paper, it looked like representation. Black communities would finally elect Black representatives. Hispanic communities would elect Hispanic representatives. But the effect was more complicated than that. Because while it guaranteed some seats for Democrats, it also made surrounding districts more Republican. And that was fine with Democrats because the total math worked in their favor. This wasn't about fair representation anymore. It was about manipulation disguised as progress. Every bizarre serpentine district line you see winding through cities, connecting neighborhoods that share nothing except racial demographics, that's the fingerprint of the strategy. And it worked spectacularly. For decades, Democrats enjoyed an advantage, estimated at somewhere between 20 and 35 extra seats in the House of Representatives. Seats they didn't have to fight for. Seats locked in by federal law and court orders. Now, imagine you're a Republican strategist in 2025, looking at these maps. You know that the only reason certain districts exist is because courts forced them into existence under Section 2 of the Voting Rights Act. You know that the demographics have shifted. You know that the Supreme Court has already started questioning whether race-based policies are still constitutional. And you see an opening, not just a small one, a massive one. That opening is Louisiana versus Clay. The case traces back to 2022, when a group of black voters in Louisiana argued that having just one majority black congressional district limited their voting power. They sued, they won, and the state was ordered to create a second majority black district. Republicans in the state legislature complied, reluctantly. But a different group of voters, non-black residents in the newly drawn district, immediately challenged it. They said the new map discriminated against them, that by sorting voters primarily by race, the state had violated the Constitution's promise of equal protection under the law. And here's where it gets interesting. Louisiana's government, now controlled by Republicans, changed sides. At first, they defended the original map. Then they realized they could argue something bigger. They could argue that Section 2 itself, the entire framework that forces race-based redistricting, might be unconstitutional. They took that argument to the Supreme Court. The justices could have dismissed it. They could have narrowed the question. Instead, they expanded it. They scheduled a rehearing and explicitly asked whether Section 2 conflicts with the 14th and 15th Amendments. That tells you everything you need to know about where this is headed. The court isn't just kicking the can down the road. They're preparing to make a landmark decision. And the timing couldn't be more consequential. If they rule the way analysts expect between January and February of next year, that gives Republican-led states just enough time to redraw their maps before the 2026 midterms. But before we get ahead of ourselves, let's talk about why this isn't the first domino to fall. It's part of a sequence. Back in 2013, the Supreme Court handed down a decision in a case called Shelby County versus Holder. That case challenged a different part of the Voting Rights Act, the section that required certain states, mostly in the South, to get federal pre-clearance before changing any voting laws. The court struck it down. Chief Justice Roberts wrote that America had changed enough since 1965 that these special restrictions were no longer justified. The dissent was fierce. Critics said the decision would open the floodgates to voter suppression. But the majority held firm. Times had changed, and the law needed to reflect that. Now, more than a decade later, that same logic is being applied to Section 2. If the country has made enough racial progress that we don't need pre-clearance anymore, why are we still dividing voters by race when we draw district lines? It's an uncomfortable question. One side hears it and thinks, finally, we're living up to the promise of colorblind equality. The other side hears it and thinks, you're tearing down protections before the work is finished. Both sides believe they're defending justice. That's what makes this so volatile. Section 2 is the fault line beneath American politics.
It's the piece of the Voting Rights Act that prohibits any voting practice that results in discrimination against racial minorities. In the context of redistricting, courts have interpreted that to mean states must create districts where minorities have the opportunity to elect candidates of their choice. In practice, that has meant decades of race-based map drawing. But after recent Supreme Court rulings, especially the 2023 decision striking down affirmative action in college admissions, there is now a clear legal precedent that demands consistency. If racial discrimination is unconstitutional in one area, it has to be unconstitutional in all areas. You can't say it's illegal to consider race in college admissions, but required to consider race in redistricting. That contradiction is exactly what the court is preparing to resolve. And when they do, the math changes everything. Political analysts have run the numbers over and over, and they all point to the same conclusion. If Section 2 falls, Democrats could lose somewhere between 15 and 35 seats in the House, depending on how aggressively states redraw their maps. Those seats are concentrated in the South and parts of the Midwest: Louisiana, Alabama, South Carolina, Georgia, Tennessee, Mississippi, all states currently holding districts that were created or preserved by court order under Section 2. But it doesn't stop there. Combine this ruling with redistricting efforts already underway in states like Texas, Florida, North Carolina, and Ohio, and you're looking at a potential swing of more than 40 seats before a single vote is cast in 2026. 40 seats. That's not a shift, that's a realignment. For Democrats, that's not just a bad election cycle. It's existential. Their entire strategy for maintaining power in the House has relied on these maps. Without them, they would need to win swing districts, competitive, persuadable districts on a scale they haven't managed in years. To progressives, this isn't about lines on a map. It's about ideology, legacy, and control. They argue that removing these districts would dilute minority votes and destroy representation, that without Section 2 protections, states would go back to the bad old days of racial gerrymandering designed to silence Black and Hispanic voters. They see this case as an attack not just on a law but on the entire civil rights framework built over the last 60 years. And they're not entirely wrong to worry. There are real risks if states abuse their new freedom. But critics of race-based redistricting point out a deeper irony. In trying to end discrimination, these districts ended up codifying it. They created racial partitions, sorted voters into demographic boxes, and told them their identity was more important than their ideas. They made race the predominant factor in political representation, which is exactly what the civil rights movement fought against. The question isn't whether minorities deserve representation. Of course they do. The question is whether the best way to achieve that is by sorting people into districts based on skin color or by creating competitive districts where everyone's vote matters equally. Now, the Supreme Court stands at that crossroads, and the whole country is watching. Democrats know what's coming. You can hear it in the way they talk about this case. They're calling it a nightmare, a disaster, a five-alarm fire. They're not exaggerating. This is the legal earthquake they've been dreading since Trump reshaped the Supreme Court. And here's the part that makes it even more painful for them. This is a slow-motion defeat they saw coming but couldn't stop. Because here's the thing about the Supreme Court. It doesn't move fast, but when it moves mountains. And right now, it's preparing to move one that's been sitting in place since the 1982. The ruling is expected sometime between January and February of 2026. That timeline isn't an accident. It's perfectly calibrated to maximum political impact. By delivering the decision early in the year, the court gives Republican-led state legislators just enough time to redraw their maps before the 2026 midterm elections. And those states are ready. They've been preparing for this moment. Legal teams have draft maps sitting in drawers.
Data analysts have been running simulations. The moment the ruling drops, they'll move with surgical precision. But the effects won't be contained to just one election cycle. This is the kind of decision that ripples forward through time, reshaping the political landscape for decades. By 2028, when the next presidential election rolls around, the entire structure of congressional power could look completely different. And it's not just about the maps themselves. It's about everything connected to them. Think about population shifts over the last few years. Millions of people have left blue states like California, New York, and Illinois, moving to red states like Texas, Florida, and Tennessee. Some left for taxes, some for politics, some just for space and sunshine. Whatever the reason, the effect is the same. Blue states are losing population, and red states are gaining it. That means fewer congressional seats for Democratic strongholds and more for Republican ones. The census has already started reflecting this. Now, imagine layering the Supreme Court decision on top of those demographic changes. Then add in another factor: mass deportations and self-deportations. Over the last year or so, somewhere between 1 and 3 million people who were in the country illegally have either left voluntarily or been removed. Most of them were counted in the 2020 census, which inflated population numbers in certain districts that leaned heavily Democratic. When the next census happens, those numbers will shrink, and so will the representation those areas receive. Combine all three forces, this court ruling, population migration, and changing census data, and you're looking at a structural realignment of American politics on a scale we haven't seen since the 1990s. For Democrats, the nightmare scenario isn't just losing seats, it's losing the ability to ever get them back. Because once these districts are redrawn without racial quotas, there's no mechanism to force them back into the old configuration. The only way Democrats win those seats again is by actually winning voters. Not by legal mandate, not by court order, but by persuasion, by policy, by showing up and making the case. That's a very different game than the one they've been playing. And here's where the deeper ideological collision comes into focus. This case isn't really about maps. It's about meaning. It's about what America believes fairness actually is. For decades, progressive politics has been built around the idea of group identity. Race, gender, sexual orientation. These categories became the organizing principle of political representation. The argument was that people from marginalized groups could only be truly represented by someone from the same group, that only a black representative could represent black constituents, only a woman could represent women, and so on. That philosophy led to policies like affirmative action in education, diversity quotas in hiring, and yes, race-based redistricting in politics. It was always sold as temporary, as a corrective, as something needed to level the playing field after centuries of discrimination. But temporary became permanent, corrective became entrenched. And now, a generation later, the Supreme Court is forcing the country to ask, when does correction become discrimination? When does protection become preference? On one side of this divide, people argue that we still need these protections because racism hasn't disappeared. That yes, we've made progress, but structural inequality is still baked into systems. That removing race-conscious policies now would be like pulling a swimmer out of the pool halfway to the other side and saying, you're on your own. Now, they see this Supreme Court case as part of a broader conservative project to dismantle civil rights protections under the guise of colorblindness. On the other side, people argue that true equality means treating everyone the same regardless of race. That the whole point of the civil rights movement was to get to a place where race didn't matter, where everyone was judged by character and ability, not skin color. That if you keep sorting people into racial categories, even for good reasons, you're perpetuating the very thing you claim to be fighting against. They see this case as finally fulfilling the promise of equal protection under the law. Both sides believe they're defending justice. Both sides point to history, to data, to moral principles. And that's what makes this moment so volatile. Because when the Supreme Court rules, it's not just settling a legal question, it's declaring which vision of America is correct, which philosophy gets written into law for the next generation. And no matter which way the court decides, half the country is going to feel like something sacred was just taken from them. But here's what's fascinating. When you step back and look at the bigger picture, this case only exists because of decisions made years ago. Decisions most people forgot about the day after they happened. Decisions that seemed purely procedural at the time, but turned out to be the most consequential moves in modern politics. I'm talking about Supreme Court appointments. Specifically, the 3 justices appointed during Trump's first term. Think about it. When Trump took office in 2017, the Supreme Court was narrowly divided, with Justice Kennedy as the swing vote. Then Kennedy retired. Then Justice Scalia's seat, which had been held open, was filled. Then Justice Ginsburg passed away. Over the course of 4 years, Trump appointed 3 justices to the court: Gorsuch, Kavanaugh, and Barrett.
At the time, Democrats were furious. They called it court packing. They talked about expanding the court to offset it, but the damage from their perspective was done. What they didn't fully appreciate then was how long the consequences would last. Supreme Court justices serve for life. Gorsuch is in his 50s. Kavanaugh is in his 60s. Barrett is in her 50s. They could be on the court for another 20 to 30 years. Every major case for the next generation will be decided by a court shaped in those 4 years. And Louisiana versus Clay is just the beginning. This is what people mean when they talk about the long game in politics. Trump didn't just change policy, he changed the institution that decides whether policies are constitutional. He shifted the entire gravity of American law to the right, and that shift will outlast him, outlast his political opponents, and outlast most of the people currently in Congress. Democrats are only now beginning to understand just how complete that transformation was. And the irony is, they enabled it. When they blocked Merrick Garland's nomination in 2016, Republicans learned they could play hardball with the court and win. When Democrats threatened to pack the court in 2021, they revealed they had no real plan to counteract what had already happened. They were fighting yesterday's war while their opponents were already preparing for tomorrow's. So, here we are. The Supreme Court is poised to deliver a ruling that could hand Republicans something between 15 and 40 seats in Congress without a single campaign ad being run. The legal framework that protected Democratic dominance for decades is about to collapse. And the justices delivering that decision are the same ones appointed during a presidency Democrats still haven't fully processed.
For the first time in decades, representation in Congress will be drawn based on population and geography, not racial engineering. That means districts will be more competitive. It means Democrats would need to win voters in places they've taken for granted. And it means Republicans would have a structural advantage going into every election until the next major demographic or political shift. But there's another side to this that doesn't get talked about enough. Competitive districts are good for democracy. When seats are locked in, whether through gerrymandering or court-mandated racial quotas, representatives stop listening to their constituents. They don't have to. Their re-election is guaranteed. But when districts are competitive, when every election could go either way, politicians have to actually show up. They have to make their case. They have to govern responsibly because voters have real choices. So while Democrats will lose seats, the country might actually gain something more valuable: accountability. Representatives who know they could lose their jobs tend to do better work. They listen more. They compromise more. They focus on results instead of rhetoric. And voters get to feel like their vote actually matters, not like it's just one more data point in a predetermined outcome. That's the trade-off. Less guaranteed representation for specific demographic groups, but more competitive democracy overall. Less predictability, but more accountability. Democrats will fight this with everything they have. They'll call it racist, they'll say it's voter suppression, they'll warn that minority communities will lose their voice, and some of those concerns are legitimate. There are absolutely states that, if given the chance, would draw maps designed to minimize minority voting power. That's a real risk, and it needs to be watched carefully. But the counter-argument is equally powerful. If we believe in equality, if we believe in the principle that every vote counts the same, then we can't also believe that some votes need to be grouped together by race to count properly. We can't say discrimination is wrong and then build discrimination into the law. Even if the intention is good, at some point the training wheels have to come off. At some point we have to trust that democracy works without engineered outcomes. The Supreme Court is betting that point is now, that America has changed enough, matured enough, that we can finally move past sorting voters by skin color. Whether that bet is right or wrong, we're about to find out. And the consequences will be measured not in months, but in decades. So what happens next? The court delivers its ruling sometime in the next few months. Republican-led states immediately begin redrawing their maps. Legal challenges follow, but with the Supreme Court having already spoken, lower courts have limited room to intervene. New maps are in place by late spring or early summer of 2026.
candidates start filing under the new districts. The midterm campaign season begins, and Democrats realize they're fighting a completely different battlefield than they expected.
By Election Day in November 2026, the first results start rolling in. Republican pickups in the South, surprising holds in districts Democrats thought were safe. By the time all the votes are counted, the GOP has expanded its majority in the House by somewhere between 20 and 40 seats. Democrats lose key committee positions. Their ability to block legislation evaporates, and the progressive wing of the party, which had been ascendant, suddenly finds itself powerless and furious. Then comes 2028. The presidential election dominates the headlines, but down-ballot races matter just as much. With the new maps firmly in place and no legal mechanism to challenge them, Democrats face a hard truth. They have to win the old-fashioned way: persuasion, better candidates, better ideas. And if Trump's administration has delivered on its promises, if the economy is strong, if immigration is under control, if international conflicts have cooled, that becomes an almost impossible task. This is the future Democrats are staring at, not just one bad election, but a structural disadvantage that lasts for years. It's why they're calling this a nightmare. It's why progressive legal groups are pouring millions into trying to stop it. They know what's coming. They've known since the moment the Supreme Court agreed to rehear this case. The writing has been on the wall. They just haven't figured out how to read it to their base without causing complete panic. For Republicans, this is vindication. It's proof that playing the long game, fighting for the courts, appointing judges with a clear judicial philosophy, it all matters. It all pays off. Not immediately, not in headlines, but in moments exactly like this one, when decades of strategic patience deliver a generational victory. For the rest of us, it's a reminder that the most important political decisions often happen quietly, that the cases that reshape America don't always make the front page until it's too late to change them, and that the world we live in tomorrow is being decided by arguments happening in marble chambers today. So where does that leave us? What's coming isn't just another Supreme Court ruling. It's a reset of how America defines equality. The decision will echo through every election, every policy, and every neighborhood for a generation. It will change who gets elected, which laws get passed, and how power is distributed across the country. And whether you cheer that outcome or mourn it depends on one simple question. Do you believe equality means sameness, or do you believe it means fair rules for everyone, regardless of who wins? I want to hear what you think. Do you believe the court is correcting decades of imbalance or dismantling protections that still matter? Do you think America has changed enough that we can stop sorting voters by race, or are we moving too fast? Leave your thoughts in the comments. And if you found this breakdown helpful, if it gave you a clearer picture of what's about to happen and why it matters, hit that like button, subscribe to the channel, turn on the bell so you don't miss what happens next. Because once this ruling drops, once these maps are redrawn, the political landscape of America will never look the same again. This is the kind of moment that defines an era, and you're watching it unfold in real time.